And welcome to Pro Bono Partnership of Atlanta's, oops, sorry. Good morning and welcome to Pro Bono Partnership of Atlanta's monthly webcast. Our webcast today is on conducting solid internal investigations, and I'll introduce our wonderful speaker in just a few minutes. I'm Lori Shapiro with Pro Bono Partnership of Atlanta, and I wanted to share a little bit of information with you about Pro Bono Partnership of Atlanta before we get started. The mission of Pro Bono Partnership of Atlanta is to maximize the impact of pro bono engagement here in the greater Atlanta area by connecting volunteer attorneys with nonprofits that are in need of free business legal services. So if you need legal services, please contact us through our website, and let me give you some information about how to become a client of Pro Bono Partnership of Atlanta. In order to be a client, your organization must be a 501c3 nonprofit. You have to be located in or serve the greater Atlanta area. You need to serve low-income or disadvantaged individuals and be unable to afford legal services. So if you fit into that criteria and you're not already a client of ours, please feel free to go onto our website, and you see our website address there on the slide, and request legal services from us. In addition, there are free webcasts and workshops that we put on a monthly basis, and there are a lot of other resources on our website that are available to you at no charge. So please feel free to take advantage of that information. As with any public information session or public session that we put on, this webcast is for informational purposes only, and nothing that is shared in the webcast can be construed as legal advice. I am very excited to introduce to you Ginger McCrae, who is an attorney with Employment Practices Solutions. Ginger has an extensive background in the law, and she has worked as an in-house attorney and as a law firm attorney. And in her current role with Employment Practices Solutions, she provides training on a broad range of employment issues, including employee investigations that we're going to talk about today. And Ginger also conducts investigations and provides advice to employers on personnel practices and procedures. So we are thrilled to have her here with us to share her expertise today. Thank you, Ginger.
Thank you, Laurie, for that great introduction. And it's my pleasure to talk with you, you folks out there who are listening in today and who might see this later, about a topic that's very important to me and has been an important part of my career. As Laurie said, I am an attorney. I also work as a consultant with Employment Practices Solutions. And as a consultant, I don't give legal advice, but I provide services that are important to maintaining compliance with legal requirements in the workplace. Investigations is an area that I like to think of it as the sort of merger of the law and human resources. It really, there's a lot of overlap, and it's important for organizations to understand the process of a solid internal investigation and the importance of that, and how to utilize those to maintain legal compliance and good employee relations. So just to jump right into the information here that I've provided. Workplace investigations have many, there are many reasons for doing those, but there are three major reasons in my mind. And the first is that if you have it's just good business practice. If you have a difficult question to answer in any area of business, you're going to want to gather the best information in order to make that decision, to solve that problem. So internal investigations are a way to gather information to address an employee relations issue, and do that based on solid, reliable information. Internal investigations are also a great risk management tool. I don't want to get too much into the law here, but if supervisor or manager is accused of harassment, and the employer follows, it has a policy with a complaint procedure, it does an investigation and takes corrective action, then the employer should have a defense in any sort of legal action that follows based on a claim of harassment or discrimination. It should have a defense to those claims. So it's a great risk management tool to prevent legal liability. And the third reason is that it really sends the right message to employees in the organization. It lets employees know that the employer cares about their, what's going on. If they have a concern, that the employer is interested in that, wants to know about it, and that the process often leads to a resolution of the issue without an EEOC charge or litigation. So those are the main reasons for conducting solid internal investigations, and we'll talk about the process as we move forward in the webcast. So when is an investigation needed? The main areas that come up, and most of the investigations I've done have involved claims of harassment or discrimination. But that's not always the case. I mean, those are the obvious situations when you might do an internal investigation, but there are others. Ethical violations come to mind, and those are things that employees are more and more conscious of, and there may be a heightened sensitivity in a nonprofit environment to use of resources, the organization's resources, and those sorts of things that could be an ethical issue. And I've done investigations that involve complaints of potential ethical violations. I call to mind a complaint where someone accused anonymously, and these are often anonymous. Two executives were accused of violating the employer's policy by including expenses for their spouses on an outing that they claimed a reimbursement for by the organization, but someone felt that their spouses were there and that those expenses should not have been claimed for reimbursement. There's another situation I did involved an HR employee who was alleged to have been in a undisclosed relationship with an employee for whom that HR supervisor had responsibility. And employees who raised the concern felt that this person was getting preferential treatment from the HR employee. So that's a conflict of interest type of situation. But there can be other, other issues that come up, and you'll see some of them there that are listed on the slide. So it's not just a tool for harassment and discrimination, but consider it when you have other concerns that are raised in the workplace. So how to choose the investigator. In a small organization, that can be somewhat of a challenge. But anyone can do an investigation if that person has taken the time to understand the company's or the employer's policy, and to try to gather some information on the process, and has some experience in interviewing people. The other characteristics that are important are someone who can maintain confidentiality. That's hard for people sometimes. It's hard for me sometimes to do that, but you always have to remind yourself that you can't talk to other people about the work you're doing as an investigator. You need someone who can be fair and impartial, and who has no relationship to the complainant or the subject. And again, in a small organization, that's where it can be a little tricky to find someone who is outside that reporting relationship. So if you have someone who is accused at a high level in the organization, HR may report to, or the person with HR responsibilities may report to that person, or or most people in the organization may report to that person. So in those cases, you might consider bringing in someone from the outside or asking help from your board of directors. One of the members of the board may be able to conduct the investigation or find a resource for you for that purpose. And it's important to, it will rarely come up that that person will have to be a witness later on, but it could. So just consider that. You want someone who could actually explain to a jury what they did and why they made the determination that they did. All right, so let's just drill down now into the process of the investigation itself. And before you dive into interviews, what I suggest is that you take time to understand what the concerns are. Sometimes the person will submit those in writing. It's not necessary to do that. I find that you shouldn't require someone to put their complaint in writing, but I think it's fine to suggest that, because what I find is that helps that person really think through what their concerns are, and it helps them articulate them in a way that they may not have thought about previously. So if you do have a written complaint, you may be able to use that to identify the issues in the investigation. So that should be your starting point. Sometimes you won't really know what those issues are until you interview the complainant. But as soon as possible, I recommend identifying the issues in the investigation and really writing those down, making those clear. So, and it could be as simple as, are the comments that are alleged by the complainant, are they substantiated by the information gathered? Is there information that those comments were actually made? And if so, do those comments or conduct, do they violate the organization's policy? So that's just a very simple and generic formulation of the issues, but again, it's, I think, helpful for the investigator to do that to make sure that you're focused in on the actual goals of the process. You can certainly expand those, and you may need to. So if you interview the complainant and the complainant alleges retaliation occurred, then you'll add an issue to your list of issues for retaliation. So the order of the interviews. The standard protocol is to speak with the complainant first, then speak with the people who might have information based on what the complainant says and what other documents reveal or just circumstances reveal who that reveals might have information, and then interview the subject last. Sometimes there is an instinct to just go right to the subject and ask him or her, did this happen? I would avoid doing that. Try to resist that urge, because it's just very helpful if your investigation is looked at later on, that you follow this protocol. And it also makes the interview that you have with the subject, whenever you do have that, it makes it more meaningful and complete. You don't want to have to keep going back to that person if you can avoid it. I prepare an outline of questions based on the information I have. You don't have to script it out too tightly or follow that too closely, but the outline helps me make sure I don't forget something. So I would recommend doing that. Some people ask, well, how do I notify people who are going to be interviewed? And that can be sort of tricky. And what I suggest on that is to not notify people who are third-party witnesses or not directly involved. I suggest not notifying them until perhaps the day before their interview. And then at that point, just let them know that the organization takes concerns expressed under It's anti-harassment policy, if that's what it is, seriously, and that their cooperation is requested in gathering information about a concern that's been expressed, and just state the expectation that they will cooperate. I don't give them any more information. I would not suggest giving them more information at that time. At the time of your interview, you can then explain a little bit more about the process. So documenting the interviews. This may seem a minor point, but it's an important point, particularly if your investigation becomes an issue later on in the EEOC charge or in litigation. I was an expert witness once in a case against a restaurant chain, and the HR, someone from Human Resources had done the investigation, and I reviewed her notes, and they were, they only had the first name of the witness at the top of the page. They were undated, very little detail. And it was really hard to follow what that person had done, what questions had been asked, what information had been imparted by the witness, and they just looked very unprofessional. So, I don't type my notes. I handwrite them. A lot of people now are doing that, doing their note-taking by computer, and that's totally fine. But I would just be sure to include all the pertinent information, of course, the date. If there are other people present, record that. Record any documents the witness agreed to provide. Put that in your notes at the end of the interview. Review them afterward and clean them up. And then also, I would suggest confirming at the outset of the interview that the witness is not recording the interview. I don't require them to show me their phone, but I think that's happening more and more. And what I tell the person is, I say, I'm not recording this interview, and I would ask that you not do so either. And usually they will say, well, every time they have said, no, I'm not. If they are, then they're not telling the truth on that. So, and sometimes they ask, and I just say, no, that's really not a part of my practice. Feel free to take notes, though, of whatever we discuss. I've had witnesses ask me to review my notes, read the notes I took at the end of an interview, and typically I don't allow them to do that, but I will read them to them. If they want to hear what I took down, I don't have a problem with that. I want to be transparent, so I will read the notes back to the witness, and if they have any questions or corrections, then they can make them at that time. So these are some of the just basic commandments for an investigator. Never express an opinion or a judgment to anyone you're speaking to. You don't know what will happen with the next person you speak to, so your opinion or judgment could totally change. It's all sort of a puzzle that you need to wait until the end when you think you have enough information. And even when you have enough information, you don't want to tell someone involved directly until all the decisions are made and everything is concluded what the findings are. So avoid doing that. Don't write your opinion or judgment in your notes. Many people have been tripped up by that. By doing that, and then it comes back, and it's right there in their notes. Forget a recent example of that. The investigator wrote something really incriminating, or this is bad for us in the margin. That's not something that you want to do. Be professional, not overly aggressive. Everyone has to develop their own style as an investigator. I find that sort of a softer approach is better than you get more information that way than a more aggressive approach. But people have to do what feels comfortable for them. Remain objective at all times. If a witness does something really odd in an interview, like storms out of the room, I think that's something you can record. Typically, I would just record what's said. But if something sort of odd like that happens, if a witness is emotional, and sometimes there are a few tears, I usually don't record that, but sometimes people are really emotional. So I might make a note if that occurs. Otherwise, I'm going to pretty much stick to what is said in the interview. Sometimes people say something and you feel that you need to acknowledge that in some way, but you don't want to agree with them. So if I feel that that person really needs to hear something from me, I will say, I hear what you're saying. I understand what you're saying. That is a neutral way to acknowledge that you're hearing that person. You care about what they're saying, but you're not necessarily agreeing that it happened the way they describe it. Okay, so some interviewing techniques. Just establish a rapport with the witness. I would not just jump right into, what happened here, or why did you do X or Y. I try to take a minute or two to put the person at ease. And then let them tell the story, particularly the main parties, the complainant and the subject. Just ask them, what happened. Start with open-ended questions. Typically, people will take that ball and run with it, and you're going to just listen as an investigator or the interviewer. And sometimes they get too far afield, and you have to rein them in a little bit and keep them focused on the issues. So that's the one scenario. Then you have the other scenario where people won't say anything, and you have to just really work to get the information out of them. You try not to ask leading questions, but it may become important to do that or necessary. For example, did you, a more broad question would be, can you think of any time when your supervisor, used profanity or was unprofessional in the workplace? And, they may say, well, I don't know what you mean, what's unprofessional? And then you may have to get a little more specific and ask more pointed questions. In interviewing the complainant, as I said earlier, try to be supportive of that person, again, but neutral. Ask the person what they want to, what they want to see as a result of their complaint. My practice sort of evolves over time, and early on, I was reluctant to do that, but my clients want to know that. So they want to know what the complainant would like to see happen from the investigation. So over time, I've come to see that that's a good question. Sometimes people will reveal a lot when you ask that. And what I will say is that, I can't guarantee what will happen. But what, if you had your preference, what would you like to see? Encourage the complainant and all witnesses, but particularly the main parties to let you know if they have any additional information, if they think of anything else that would be helpful. And certainly let the key parties, the complainant and the subject, let them know that someone will get back to them. A key area is trying to unlock these big generalizations that people use sometimes when you interview them. They harassed me on a daily basis. So you have to break those broad statements down into facts and behaviors. So that's an important thing to do as an interviewer. Ask the person who felt an investigation I recently did, someone told me that the way her supervisor approached her was harassing. So that doesn't really give you much information. So you have to ask them, what in their demeanor, what in their voice felt harassing to you. Were there any witnesses to that? Have you observed that person speak to other people in that, or approach other people in that way? So those are some ways to really drill down on those broad statements and try to get facts. I've mentioned a couple of these points in interviewing third parties. For those people who are not directly involved but may have information, I try to not lead them too much, but sometimes you have to ask them about a specific situation. And then they'll say, oh, I know what this is about. I just don't respond to that because, I'm not going to validate that, their speculation. I just say, just repeat the question. Can you tell me, if you observed this incident on X or Y, on X or Y date? And for everyone you interview, I go over a few things at the beginning of the interview, and retaliation is one of those. Be sure to emphasize the prohibition on retaliation and encourage people. And I usually explain to them what that means. I said, I tell them that means you cannot be adversely affected because you raised a concern or because you were interviewed in this process. And encourage them to raise any concerns of retaliation with me or someone in the organization. Interviewing this subject, that can be challenging because sometimes people have never had this happen to them before. They've never been accused of misconduct in the workplace. So, I try to use the same approach with that person. Be neutral, be transparent. I do not hide the ball at all with the subject. I let him or her know what the allegations are so that they can make a complete response. I just feel like that's the only fair way to do it. Ask that person who else, of course, would be helpful to interview. Who else might shed some light on their position. Why would someone make the allegation that they did against them? And ask if they've had any other complaints made against them in their with this same organization or in their career. And again, stress non-retaliation. For that person, it's extremely important that they not retaliate against the person who made the complaint. So determining credibility. Sometimes this sort of gets to the heart of the investigation process. We've all heard the classic he said, she said scenario where people say something completely different and there are no witnesses. I confront this all the time, but there's a classic example. A year or so ago, I did an investigation involving two lawyers. It was a male supervisor and a female subordinate. He invited her to his apartment one night after work. She went, and she alleged that he made a sexual advance on her and professed his sexual attraction to her and professed his belief or expressed his belief that she felt the same way. He denied all of that, and of course there was no one else there. So what were some of the factors that I used to determine if whose story was more credible? In this investigation, the subject was not very upset that these allegations were made. And he told me that he could easily work with this person in the future. And that just didn't make sense to me. I mean, if someone had made, serious, what I believe were totally fabricated allegations against me and really threatened my career, I think I would have been a little more reluctant to trust that person in the future and have any sort of ability to work with them. The other factor, there are many factors, but the other main factor here is that the complainant called someone, a coworker, that same night, told the story in consistently each time she told it. So I interviewed the person that she told the story to that night. Then she called her second level supervisor in a day or two, told the story consistently each time. So, I determined that's a hard call, but I determined that she was more credible and that her what she had alleged was substantiated. So reaching a conclusion does involve making a credibility determination sometimes. You have to consider what corroboration you have from those people involved or others. And sometimes the documents, text messages, that's becoming a bigger and bigger part of what I'm looking at in investigations. That totally corroborated a story of a complainant in an investigation I did recently. So make those findings on those key issues to conclude the investigation. And you don't have to be perfect. The key is to reach a reasonable conclusion after a good faith investigation. That's the requirement of the employer. And the standard of proof, if there is one, is really just more likely than not. It's not, this is not a legal proceeding. It's not beyond a reasonable doubt. But most investigators would adopt the sort of more likely than not standard. And there may be times when you just cannot reach a determination. It's just too close. But if you've done the work, if you've interviewed people carefully, you've weighed credibility, those should really be, a extreme minority of the situations. And it's important to resolve the matter. What I find when people do internal investigations is that they have other responsibilities, and they may tend to back burner this because it's sort of a hard thing, and it's not your favorite thing to do at work. I would counsel against that. Do not let the information sit. It'll get stale. You will, when you come back to it, it'll be hard to come back. The information won't be as fresh in your mind. So I would recommend that you work through this as quickly as possible to maintain the integrity of the information and the process. And the other reason is because people need a resolution. I've found that if you finish the investigation, make findings, people will move on. But if it's hanging out there for weeks, then it's hard for people to move on. I would suggest preparing a written report. It doesn't have to be elaborate, but it will be a great source of information should you need to come back to it. If other people in the organization want to look at it or review it, then you'll have a report. But keep in mind it is discoverable, so prepare it so that someone else may ultimately read it. Do not make legal conclusions. Do not say, I find that X harassed Y. There's no need to do that. And the standard for harassment is, it's really sort of depends on, the jury, what the judge says. That's a legal admission. So what I always couch my findings in are just tie them to the allegations. Is the allegation that X did Y, supported by the information gathered or not? And if so, is that a violation of the employer's policy? That's as far as you really need to go. Create a file for all of your information. Gather it all together. Don't put it in the personnel file. The only thing that would go in someone's personnel file is any sort of corrective action that's taken. And I'll get to that in a moment. But just collect all of your information there and put it in a confidential place. You definitely want to close the loop with the complainant and the subject. Let the complainant know what your findings are and why, just in general, why you made them. A lot of my clients ask me to do the debrief with the complainant and sometimes with the subject. So I usually keep that at a fairly high level. But people, I find that people accept the findings, that they they're happy that they were heard, that there was, even if they are not in favor of them, they're happy that the process was done, that they were treated with respect, and a finding was made. You want to document, that you did follow up with a complainant. Look for, potential gaps. So the complainant or someone may have said, well, I didn't know we had a complaint process. I didn't know anything about this. I didn't know who to complain to. So that may give you an indication that you need to recommunicate your complaint process or who complaints should be submitted to. So corrective action. It can really take any number of forms, and it should be calibrated to the findings, the seriousness of the conduct. Also, you want to consider how if the organization has any past history in dealing with similar situations, and just what the fairness factor. What would be fair? There are all sorts of possibilities. A warning if you find that there was misconduct, a warning, a written warning, a suspension, termination in serious cases, sending that person for some one-on-one training. More and more, that is a corrective action that people are taking. But record any corrective action that you take in that person's personnel file. Okay, so just to wrap up, sound internal investigations can be done successfully by any organization. It's a matter of focusing on the process. The process is key. Is it fair? Is it neutral? Is it free from retaliation? Did the organization take steps based on a reasonable and documented sequence of events? So that is, that's really the key to conducting a sound investigation. As I said, work through it as quickly as possible, document it, and communicate your findings, and then the organization can move forward. All right, so that's all I had. I'll take any questions if there are any.
Great, thank you, Ginger. We do have a few questions. And if you wouldn't mind repeating the question, because I'm not sure if the microphone will pick me up or not from here. The first question is it important that the investigation process be formalized? So should that process be communicated to employees in general as to how the company handles investigation?
Okay, so the question is whether the process itself should be formalized, communicated in the form of a procedure, I think is the question. Yes. to employees. I see sort of a mixture of responses to that. Sometimes an organization has that process, a fairly detailed process in its policies. I don't think that's really necessary. Because you may not follow that exactly. There may be circumstances that you can't account for when you're writing that process. The EEOC guidance is always what I default to in terms of what the process of an investigation is. So if and all my presentation is really follows that process. So if you can show that you're following those guidelines in general in conducting your investigation, I don't think you have to formalize the process.
Ginger, you use the initials EEOC. Can you explain what that means?
Sure. The Equal Employment Opportunity Commission is, of course, the agency that enforces Title VII, the main anti-discrimination and anti-harassment law. And in 1998, I think it was 1998, the agency promulgated some guidance on conducting investigations when a supervisor is accused of harassment or really harassment. But those guidelines have been really recognized as the appropriate process for conducting investigations really of all types involving coworkers or other discrimination claims as well. So that I would highly recommend that guidance.
Thank you. Our next question is, in your experience, have you seen an apology as a sufficient corrective action for a complainant?
Well, that's an interesting question, and the question is whether I've seen an apology as an effective corrective action as a result of an investigation, and it really depends on the nature of the conduct. Sometimes people usually, when they say things, they don't intend to be offensive, and of course the standard is the impact that it has. Intent, though, is important, and if the person did not intend to be offensive and you feel that sincerely, then an apology might be appropriate. But I would also provide or include in most of those cases some finding that the person did violate company policy and put that in your file. Because if it comes up later on and the person does it again, then you're going to want to have something to refer back to. So I would at least document the fact that they violated the policy, intentionally or not.
Thank you. You talked about credibility during the webcast. What if you feel that both parties are credible?
I've had the question again is on credibility. What if you feel that both parties are credible? I've had done hundreds of investigations, and I have had a few that I felt that the parties were equally credible, and that's a legitimate finding. If you can't make a finding, you don't have anything that sways the balance one way or the other, then that's your result. The result is that the complaint was not substantiated because you didn't have sufficient information to validate it. But in those cases, what I would do is just issue a reminder to the subject, what the policy is and what appropriate conduct in the workplace is.
Great. One more question. How much information should you give to the complainant after you conclude the investigation about what you found?
The question is, how much information should you give to the complainant after you conclude the investigation? So when I do the debrief with the complainant, what I do is I just walk them through the issues. You alleged that, X said Y, or did Y to you. I found that was substantiated by the information. And then just go through each one of them. They're sort of key allegations without going too much into the facts. And if you're the internal person will want to tell the complainant, and we have taken appropriate corrective action. I would not provide any more information than that. All they need to know is that corrective action has been taken. They don't need to know if the person was suspended or disciplined or warned. They don't need to know the specifics of that, and I don't think it'd be appropriate to share that. But they do need to know that you've taken corrective action, and then I would encourage the complainant, if you have any additional concerns, please feel free to raise those immediately.
Another question about the scope of who you're interviewing and how you're interviewing folks. First, should you interview someone who no longer works for the organization?
So the question is, in determining who to interview, should you interview someone who is no longer employed by the organization? And then just another subset of that are people who have never been employed by the organization. They may be vendors or clients. I try to put those people in only if necessary category. I have an investigation now where the HR got a complaint and it appears that nothing was done, and the HR manager who was there at the time is no longer employed. I'm probably going to have to try at least to interview her. So I would do it only if necessary. If there's no other way you feel that you can get the information that's needed.
And both with regard to anyone like that and also the people who are still employees who you interview, can you tell them to keep the investigation confidential?
So the question is, when you interview people who are, particularly third-party witnesses, what can you ask them to do with regard to confidentiality? So that's a complex question. It would seem just normal that yes, you could do that, but because of some recent decisions by the National Labor Relations Board that expressed that a blanket requirement of confidentiality in connection with internal investigations violates the employee's rights to discuss terms and conditions of employment. It's a trickier question than it should be. What the board has said, the National Labor Relations Board has said, is that you have to do that on a case-by-case basis. I find that the risk of having that come up is outweighed by the need for giving the confidentiality warning in virtually every investigation I do. So I take a little bit of risk and go ahead and just tell people. Because I tell them to preserve the integrity of the process, I'm going to ask you to not talk about what we talk about in here today outside this room. And I tell them I'm going to interview other people. I want each person to come and speak with me and tell their own story without having heard from someone else what this is about. So I'm going to ask you to keep it confidential. I think that's sort of navigating that line and is a good practice in investigations.
Do you think that people should be interviewed by phone in an investigation?
So the question is the use of phone interviews. So when someone is in the area, I don't feel any need to do the interview by phone. I mean, I can go to them. We can meet somewhere and get a face-to-face interview, which is really much more meaningful than a phone interview. If someone is in Europe or they're in California and they're a fairly minor person, they're not one of the major people, then I think a phone interview is fine in those cases.
Great. Thank you, Ginger. One final question. Is it advisable to have your outside counsel or your attorney do investigations for your organization?
Well, in some cases people do that, and the problem with doing that is that if there's litigation later, then that person who is your main go-to lawyer could not represent you because they could be a witness in the investigation as the investigator. So, I'm finding more and more law firms are not doing investigations themselves. They're referring them to someone like our organization or another lawyer to do them so that they won't be conflicted out.
Right, and I will say, because we have clients on the phone of Pro Bono Partnership of Atlanta, please do contact Pro Bono Partnership of Atlanta if you need assistance with an investigation, if you're a client of ours or if you want to become a client of ours, and we can provide resources to assist you with investigations. Ginger, is there anything else you'd like to share before we wrap up the webcast?
No, I don't think so.
Okay, thank you very much for taking the time to speak with us today. Really appreciate it.
You're welcome.